Welcome to your mini lecture in Chapter 15, that is Legal and Ethical Issues in Abnormal Psychology. What I'm going to focus on today is the legal issues. We're going to talk a little bit about ethics, but not a whole lot. And there's a whole lot in this chapter, but your exam will cover predominantly the pages that I'm going to be talking about today. But also make sure that you're doing all the reading that you need to, because of course the whole chapter is a part of this lesson. Okay, so we're going to start with some definitions. Let's start with the idea of forensic psychology. The book doesn't talk about what forensic psychology is, but forensics are the intersection between psychology and the law. And so there's a whole big discipline when it comes to that. We're only going to be talking about just a little slice of that, and that is how the law looks at mental illness and how mental illness can influence legal decisions. To that end, we're going to predominantly be talking about the stuff I have here on the board. So let's start with this idea of commitment. When I say commitment, what I'm talking about is involuntarily committing someone to a hospital or to some sort of lockdown institution due to some reason with mental illness. So there's actually two different types of commitment that we talk about. The first one is civil commitment, and that is involuntary commitment due to danger. And so somebody could be committed to a hospital because they are a danger either to themselves because of suicidality or to other people because they might be homicidal. They might be destructive, like they're going to set fire to something and people could be inside, something along those lines. So that's what civil commitment is. The person hasn't actually done anything, but they're a danger to either themselves or somebody else. And so as a therapist, I want to make sure that I'm able to protect them and protect other people, so I'm going to commit them to a hospital. Then there's criminal commitment, and that involves involuntary commitment because of a crime. And we'll talk about sort of how the legal system does criminal commitment, but a crime has already occurred and therefore the person has to be committed. This actually brings us to sort of how the law looks at mental illness. The term insanity is actually a legal term. It's not a diagnostic term. You cannot be diagnosed as insane because as a psychologist, I'm not going to diagnose somebody that way. The only people who can determine whether somebody's insane is a judge or a jury. So that is a legal term, and so because of it, there's a legal definition that goes with insanity. And the way that we define it is based upon history. Make sure you look at the history of the term insanity. There's a broad history there, but predominantly we use the McNaughton rule, which came to us from the 1800s. It was a case in Britain where they first defined what would be considered insanity. And then we updated it a little bit in '84, and in the US we have the Insanity Defense Reform Act. And so based upon those two things, there's actually 3 different criteria that we can use to determine whether or not somebody is insane. So the very first one is that they did not know what they were doing. Now what does this mean? It means that because of the mental illness, for whatever reason, you don't have a memory of what occurred. So it could have something to do with sort of a blackout that occurred during your psychotic experience. It could be some sort of amnesiac sort of thing. But due to the mental illness, there's no memory, so you actually did not know what you were doing at the time. You have no memory of it. The second one, which is more common, is that they didn't know that what they were doing was wrong at the time. And this is the one that gets brought up quite a bit. So because of the mental illness, they believe that the crime they were committing was not wrong. It was a correct thing. They didn't know that they were committing a crime. The third one, which was added in '84, is this idea of volition, which is control of yourself. So if you maybe knew what you were doing and knew that it was wrong, but maybe you didn't have control over your actions, again, because of some sort of mental illness. So these things are actually really, really hard to prove. And the burden of proof, as of '84, is actually on the defense. Before that, it was the prosecution. The prosecution had to prove that somebody was not insane. But now, the defense has to prove that they are, in fact, insane, as defined by one of these 3 things. You don't have to have all 3 of them. You only have to have one of them. So, this leads us to what the verdicts could be. So if somebody has a mental illness and they committed a crime, there can be 2 different verdicts that could occur. One is not guilty by reasons of insanity. That means you have proven that one of these three conditions exists. You are in fact insane, therefore you're not guilty. Or it could be guilty but mentally ill. You have proven that you are mentally ill, however, you're still going to be found guilty because those three conditions, none of them were met. So let's talk about the difference between those two. If you're not guilty, that means you're not responsible. You are not responsible for the crime. The mental illness is responsible for the crime. However, if you're guilty but mentally ill, then you are responsible for your actions. You are held accountable for what you did. And that's a huge difference between the two of them. If you're not guilty by reasons of insanity, you don't get to go free. Most of the time you are committed. That's the criminal commitment that we're talking about. You are committed to some sort of forensics hospital, and there's no length of time there. You're committed until somebody decides that you are no longer a danger to society. So the doctors at the hospital and a judge has to agree you are no longer a danger to society. So what happens is oftentimes people think that they just get let. That people who plead the insanity plea and actually get it just get let loose. They don't. They often go in the hospital for a longer duration than if they had actually been found guilty of a crime. So you go to the hospital until you're not a danger. If you're guilty but mentally ill, you are given a time-limited sentence. So the judge and jury say, because of your crime, 2 to 3 years in prison or whatever the case may be. So you actually have a time-limited sentence. Now, the loophole is that after your sentence is up, after you pay your debt to society, people could still put you in a forensic hospital for treatment. And that does not have a time limit, again, until you're not a danger anymore. So that's possible, but not likely. And the very last thing is the focus. If you're not guilty by reasons of insanity, the focus of your commitment is treatment. We're going to try to get it so that you're no longer insane, you're no longer mentally ill. If you're guilty but mentally ill, the idea is that you may be put in jail, but you could also be put in a hospital, or you could also receive treatment while you're in jail. So it's a little bit different than just guilty, because they're saying you're guilty, but there's something else going on, and we think that you should get treatment for it. The idea is that treatment will occur, and unfortunately it doesn't always happen. So those are really the two distinct differences between not guilty by reasons of insanity versus guilty but mentally ill. Again, it means two different things in terms of responsibility, and the results are two different things. Now let's talk a little bit over here about ethics. There's one thing that I really want to clarify and clear up that the book oftentimes has wrong. The book says that there is a duty to warn. We do not have a duty to warn as psychologists. We actually have a duty to protect. So change that in your mind. It's duty to protect, not a duty to warn. What does that mean? That means that if I'm sitting with another client, if the client says, hey, I'm really, really angry at my ex, and I think I want to hurt this person, I now have a duty to try to protect that person. And in order to protect that person, I have to balance out two different things. I have to balance confidentiality, and I have to balance the protection for them. Confidentiality is an ethical statute that I am held accountable for. That means that anything that a client tells me, I have to keep basically secret. Whatever they say, I keep in confidence. Those are my ethics. However, there are some limits to that confidentiality, and that is when I have to protect somebody or protect them. So if they're talking about suicide, that would be a situation where I have to protect them. Now those are the ethics. Legally, confidentiality is actually called privilege. You've probably heard this term before, privileged conversations. And so between a therapist and a client, those are privileged conversations unless there's an exception to that privilege. So again, as a therapist, I'm balancing the fact that I am legally responsible to hold it as a privileged communication versus the fact that I need to protect, I have a duty to protect people who could be injured. This actually comes from the Tarasoff case. Let me tell you a little bit about the Tarasoff case. It was a therapist who was treating a young man named Poddar, P-O-D-D-A-R, and he expressed some anger and some homicidality towards his ex-girlfriend, whose last name happened to be Tarasoff. When during a session, the therapist became concerned, was afraid that Poddar was going to hurt her, and so he actually tried to civilly commit him. Poddar escaped, left the therapist's room. The therapist chose to break confidentiality, call the police, and asked them to arrest Potter in order to protect Tarasov. Police went to Potter's house, found him, and decided he was not a danger and did not arrest him. Well, a couple months later, Potter did in fact murder Tarasov. So there was a big legal case, big legal battle, really wondering whether or not that therapist had done enough to protect Tarasov. And that's where this legal rule comes from. It was decided that he did not do enough to protect her. And so now, as therapists, we really have to negotiate how much we do to try to protect somebody. So I could go as far as breaking somebody's confidentiality to warn the intended victim, or I could ensure that that person is locked up. Those are really my two options. Usually I want to try to lock that person up and get them some safe treatment, but if I can't find them, if that doesn't work, then I do have a duty to warn the intended victim. So that's where that all comes from. Make sure you're looking at privilege and what the exceptions to privilege are, because there's a significant number. Again, it has to do with whether you're being a danger, has to do with child abuse, elder abuse, abuse of anybody who can't take care of themselves, so a developmentally disabled person. Also has to do with legal stuff. Some legal stuff is not privileged. So if you as a client decide that you committed a crime and you think your mental status had something to do with it, then all of a sudden you open the door and we no longer have privileged communication and you're asking me to break the confidentiality. So make sure you look at all those exceptions. This again is a big chunk of what I want you guys to know from Chapter 15, but there's other stuff in there that I want you to make sure that you understand, research ethics, etc. As always, if you have any questions, please post them on this discussion forum. Thank you.